On 29 September, the Grand Chamber of the European Court of Human Rights delivered a groundbreaking judgment, the Yalçınkaya case versus Turkey. The Grand Chamber decided that the conviction of Mr. Yalçınkaya was clearly in violation of Article 6 of the Convention, right to a fair trial, Article 7, no punishment without law, and Article 11, freedom of association and assembly. Indeed, Mr. Yalçınkaya was convicted because the simple use of a communication app, Bilog, a communication app as Telegram or Signal is. Because in the reasoning of the domestic courts, the use of this app already was a proof of being a member of the Gülen movement, and by that a proof of being a member of a terrorist organization. Why it was used for, what was said, if it was said, didn't matter. There was an indication that the person used or could use Bilog, so he was supposed to be member of a terrorist organization. Between 2015 and 2021, approximately 270,000 persons have been convicted for the alleged membership of a terrorist organization of allegedly being member of the Gülen movement. Most of these individuals have been convicted on the same basis as Mr. Yalçınkaya was. Using Bilog, being member of a union, being member of an association. In the Yalçınkaya judgment, the court clearly stated, and I will quote, that the victims of these arbitrary judicial decisions suffer from an almost automatic presumption of guilt, making it impossible or nearly impossible for them to prove their innocence. More importantly, the Grand Chamber clearly stated that the problem was systemic. It's rare that the Grand Chamber uses that term, systemic, generalized. And of course, as a consequence, the Grand Chamber called on Turkey to take the necessary measures to address those systemic problems in the future. Turkey Tribunal has always stated that hundreds of thousands of people in Turkey have fallen victim of arbitrary detentions and imprisonments. The judgment, the Yalçınkaya judgment, simply confirms it. The Turkish state has obligations, legal, binding obligations to execute the judgments of the European Court. This means that the situation of Mr. Yalçınkaya must be redressed. That's the individual measure to be taken. But there also, and the court was very clear about that, also general measures has to be taken, so to redress also the situation of the thousands of people who are victims of the same violations. For instance, by creating the possibility for all other victims of the same violations to have their rights reinstated. That's the least the Turkish state could do.